Hi everyone, I'm Neama Rahmani, former federal prosecutor, and I'm going to talk about what will be the biggest trial in American history, the United States versus Donald Trump. So how did we get here and where are we going? Attorney General Merrick Garland appointed a special counsel who was an independent prosecutor named Jack Smith to investigate the former president for a number of alleged violations of federal law, including the Capitol riots, conspiring to overthrow the 2020 election, and unlawfully maintaining classified materials, which of course is the issue in this case. So under federal law, classified materials are to be maintained at the National Archives in Washington, D.C., or at a SCIF, which is a secured facility. It became apparent to the archives that Donald Trump had taken some classified materials with him when he left the Oval Office to his home in Mar-a-Lago. The archives requested the voluntary return of the documents for over a year, and when it became clear that the president wasn't fully complying, they told the president's lawyers that they would make a referral to the Department of Justice. The Department of Justice is the federal agency that enforces the law when agencies can't get voluntary compliance. The archives made the referral to the DOJ, who convened a grand jury. The grand jury issued a subpoena for the return of the documents. And a lot of the allegations in the indictment relate to Trump and his valet, Walt Nauda's response to that grand jury subpoena. Trump did return some documents, but not all the documents in response to the subpoena. And then the Department of Justice took the unprecedented step of going to a judge and having the judge sign a search warrant to raid his Mar-a-Lago home. Never in the history of the United States has something like that happened. So the counts in the indictment, the first 31 counts, are violations of the Espionage Act. That doesn't mean that Trump was spying for another country, but that he was mishandling documents related to the national defense. Now, national defense is not the same thing as classified, but historically, when the Department of Justice has charged violations of the Espionage Act, they've related to classified documents. So the 31 counts aren't documents that Trump voluntarily returned to the archives, or even documents that were produced in response to the grand jury subpoena. It was documents that were still at Mar-a-Lago when federal agents executed that search warrant. So those counts carry a potential 10-year sentence in federal prison. Not saying Trump's going to get 10 years, but that's the statutory max. I bring that up because there's also several obstruction counts, as I like to call them, and those counts carry a potential 20-year sentence in prison. And this may be one of those cases where the cover-up is really worse than the crime. And the remaining counts in the indictment charge Trump and Nauda with concealing documents from a grand jury, tampering with grand jury evidence, obstructing justice, and making false statements. And the issue is that the false statements, of course, that's a 5-year max. But it's really the 20-year obstruction counts that are really driving this case. And, when folks ask me, well, what about Mike Pence? What about Joe Biden, who have also alleged to have mishandled classified documents? I think the response would be that both of them complied when they were contacted by federal officials. They didn't keep the documents after they were informed to do so. And I think that's that cooperation, that negligent mishandling that really separates the Pence and Biden cases from Trump's, who at least is alleged to have intentionally kept the documents. The reason that knowledge and intent is important is that normally these types of cases aren't prosecuted unless the violation is willful. So Trump is saying publicly and on social media that as president or former president, he could declassify the documents. That may be well and true, but there's a procedure for doing so, which involves notifying the relevant department. And it's not clear that Trump ever did any of that. In fact, there's no evidence that he's done so. But more important than that is when Trump's saying that he could have declassified the documents, he's admitting knowledge that the documents were classified and his intent to keep them. But that's a problem for his lawyers in this case, because if that legal argument fails, he's admitted that willfulness element of both the substantive counts and the obstruction. So when we're looking at the evidence in this case, there's a couple key moments where Trump was speaking to a representative of his PAC and as well as an author and a reporter about these documents. basically admitting that he had them. I think those are the strongest pieces of evidence related to the substantive counts, and they're detailed in the beginning of the indictment. With respect to the obstruction, it's really the text messages with Nada and others. It's the video surveillance of Trump moving the boxes from his storage room to his personal residence, or causing them to be moved, as well as his communications with his lawyers, saying that, well, what happens if we don't turn the documents over, or we pluck them out? I think the challenge Trump is going to have is, those text messages don't lie, the video doesn't lie, and there's likely going to be people cooperating against him at trial, even if Walt Nada chooses not to do so. Nada, of course, seems to have been offered a deal, but at least as of the date of this video, hasn't accepted any type of offer. That's why he was wrapped up into the indictment with the former president. Now, with respect to how Trump is going to defend this case, and I fully expect him to do so, the Department of Justice can't offer any type of deal, or certainly not anything that the former president would accept, nor has Trump indicated any willingness to accept the deal, even a no-time felony. So this is a case that's likely going to go to trial. Trump can try to argue selective prosecution. I know that's something that a lot of conservatives have said it's not fair. Hunter Biden's being offered a no-time misdemeanor, and Trump is being charged with a felony. And unfortunately, when it comes to selective prosecution, at least as far as a legal argument is concerned, the defense needs to show that it's really for a constitutionally prohibited reasons, such as your race or religion or national origin. It's unclear that that's what's happening here. Obviously, we talked about the Trump defense that these documents were declassified. The problem with that is it fails. It does admit that, the knowledge and intent, but it really doesn't address the obstruction counts either. I think defense will try to get some of the attorney's statements and notes suppressed as violations of the attorney-client privilege. I know a judge in D.C. has said that Trump's lawyers did have to produce those notes, but there's a different standard for discoverability as there is for admissibility at trial, and Judge Cannon is a very different judge. Speaking of Judge Cannon, Donald Trump did get a very favorable draw. She is a Trump appointee. They're in the Southern District of Miami where this case is happening. And of all the judges in the district, probably would be the most favorable to the former president. And the reason we know this is she was the judge who oversaw the discovery issues related to the search warrant. She appointed a special master because Trump had claimed executive privilege over these documents, even though it's not clear that there was any really valid basis to do so. And she appointed a special master. The Department of Justice appealed, went up to the 11th Circuit Court of Appeals, which is also very conservative, and that Court of Appeals overturned Judge Cannon. So here's someone that's been overturned once in this case, and judges don't like to be overturned, but of all the judges in the district, probably the one that is going to have the most favorable view of the former president. Now, I'm not saying she's going to do anything improper and she's not going to follow the law, but it's certainly who Donald Trump wanted. Now, a lot of Democrats are saying, well, how could this case possibly go to a judge that's appointed by Trump? Well, unless the department can prove that there's actual bias, then there's not really a good faith basis for disqualification. Judge Cannon can recuse herself, of course, if she believes that there's an inference of impropriety or at least an appearance. But if she chooses not to do so, voluntary recusal, disqualification is a pretty tough hurdle for prosecutors to meet, and I don't think they'll even go there. Prosecution in the case has been very conservative. They could have arguably filed in Washington, D.C., a much more liberal jury pool, but they chose to file in South Florida, where a lot of the alleged obstruction took place. And the reason this is important is, had they filed in D.C., I believe Trump's lawyers would have litigated the venue motion and probably been successful in getting the case moved down to Florida in the first instance. One thing to note about Judge Cannon, since she's a new judge, and the more senior judges in the district have a much larger caseload, she gets more cases off the wheel, more cases assigned at random. So even with random assignment, she was much more likely to get this case, at least statistically, than any of the other judges in the district. So I don't think there's anything improper going on there. Now, of course, Trump wants to delay this case as much as possible. As of this video, trial is set for mid-August, but Trump wants to push this case out past the November 2024 election for a number of reasons. First, if he wins the presidency, it's well established that he can't be prosecuted. The case goes away. But even if DeSantis or another Republican were to get the White House, I would expect them to try to fire special counsel Jack Smith for good cause. Can't just fire for any reason, but that's something that I expect a new president and a new attorney general to try to do. The jury pool there in South Florida is pretty divided. Biden won, but barely, by a few percentage points. So, this is the type of case that I can see potential jurors on both sides having favorable or unfavorable views of the president. And jury selection is going to be everything. Of course, because it's a federal case, unfortunately, the trial won't be televised. But you can believe that everyone in the country is going to be following the reports by the pool reporters, both inside the courtroom and any overflow room. So this is something that we're going to keep our eye on. The president and his team are going to litigate this case at every turn, file motions to dismiss, and file other motions to suppress evidence. So we're going to be talking about this case a lot more in the coming weeks and months. Thanks everyone for watching. Make sure to like, follow, subscribe, and ring the bell for notifications.